Good morning, everyone. Uh, Let us do a very good interactive session instead of just making it one-sided. To start with, I want to ask one simple question. How many of you are real owners of your flat? Real owners. Okay. How you can become a real owner? Only by purchasing or by repaying the loan? Transferring share certificate. This is one type of ownership. Whether it is the ultimate ownership. No. Unless and until your society has conveyance, you are not the owner of the flat in real sense. Yes, title is protected, you have right interest in your property. But unfortunately what happens is, the moment we purchase a flat, we start paying the EMIs, we start living there, but we generally don't really pay required attention to the real ownership, because we are generally concerned with our individual rights and well-being, not collective rights and collective well-being. Because of that particular reason, over a period of time, say past 50 years plus, the community, specifically builder community, they also paid least attention to this kind of transfer of the ownership. It is not intentional always. Sometimes it may be. But today, after 50 years or so, we have learnt a lesson collectively, and let me put it on record. Hard work of Mr. Prabhu, it is ultimate. Like, no individual can think of collective achievement, collective concerns, because as a practitioner, I am an advocate, I will be concerned with the briefs I am holding. Okay, if somebody is getting conveyance, somebody is not getting conveyance, probably I may discuss about half an hour or 1 hour in a closed group and then forget about it. But he is the one person who has taken it to all levels. Coming back to the point, after 50 years or so, we have started with this deemed conveyance. Why this particular concept has been started? It is because majority of the builders, as well as majority of the flat owners, that is societies, never cared to even address that particular issue. This is one part of the story. On the other side, if you come to the judicial process, what are the options you have? You have an option of approaching Metropolitan Magistrate. You will go and file a criminal complaint against the builder, for which there are certain defenses for the builder, certain claims as far as the societies are concerned. You will either win the case or you will lose the case. Either you or the builder will go to session court. Again he will go for revision. Again he will go for some appeal in the High Court. So it will be about 10 years game. Alternate option is, if you don't want to initiate criminal proceeding against a builder, you will go to consumer court. If at all you go to consumer court, if he is a genuine builder, proper company, they will come with their lawful submissions and contest the matter. And if at all there is a result in this particular matter, builder will go for appeal. Either you will go to the state commission and appeal the order, and again he will go to national commission, or you will go to national commission. In this entire process, there are a lot of possibilities for the defaulter to misuse the provisions of law. He will willfully remain absent, and ex parte order will be passed, and again he will pray for restoration on various grounds, and in the interest of justice, opportunity will be given. So eventually society will not get conveyance within a period of, say, less than 3 years or 5 years, because that system is like that. On the other side, if you have certain arbitration mechanism in this particular agreement, you will invoke the arbitration provision. They will never appoint an arbitrator. Again you will go to High Court. So again it is 3 to 5 years game. So thinking about all these potential issues, as well as the cost involved in approaching all these forums and courts and tribunals, Maharashtra government has come up with this particular scheme of deemed conveyance. Let me put it this way, this is not a scheme, because generally if you see last 2 years back, 1.5 years back, Honorable Chief Minister, then Chief Minister Mr. Prithviraj Chauhan had circulated a letter to each and every society. In that letter it was mentioned, till this date we are going to promote this. So it is not a scheme. As a Chief Minister, he wanted to ensure that maximum societies get conveyance. That is why he created a system, 4 district level registrars who will be adjudicating officers, who will be competent officers, and then Within that period, the government of Maharashtra wanted to assess how many societies are going to avail this particular benefit and how many societies are going to effectively get the conveyance. So it was not a scheme, it was a drive. So let us be very clear. There are some people who keep on asking questions, Arey, it was there for only 6 months or only 1 year. Now that scheme is not there. No, it is not a scheme. It is a proper amendment in the law which enables you to get conveyance anytime. So this is all about the basic concept. Your real ownership, the purpose of the deemed conveyance, how it is going to be conducted, how you are going to approach the concerned competent authority, what are your basic issues, what are basic challenges, how you want to address, and after filing or even before filing, what are the things to be taken care, why there is no big success for the deemed conveyance. So let us debate on all these issues. Okay, let us be very practical. Presuming that your society is not having conveyance and you are having multiple committees in the past 30 years or 20 years or 10 years. And one more interesting point is whether this is applicable to the only old societies who are about to get redeveloped. No, it is also applicable for a new, brand new society which is just 1 year old or 1 month old or even 10 year old. It is applicable to everybody. So, in my opinion, each and every society should initiate the required process to opt for this particular mechanism, because again, just now my learned friend mentioned about repeal or no repeal of the MOFA. If the MOFA gets repealed, naturally deemed conveyance will go, because it is eventually a part of that particular amendment. So in short, this particular option, as long as it is there, or it will be there forever, but we are not here to wait for any repeal or no repeal. When the rights are given, we have to exercise it and we have to get true ownership of the society land. Now you can raise any questions and I will address it one by one.
Sir, one point. You are saying that under the new act, deemed conveyance procedure is
No, I am not saying under. No, I am not saying under the new act. Whether it will be repealed or no repealed, that is a different issue. Today I am only saying as long as you have this particular option of deemed conveyance, societies should initiate steps to take conveyance.
That is okay. Supposing the new act has come into force, there also the provision is there.
Definitely, conveyance cannot be taken out. No, what I am trying to say is when the customized process of getting conveyance is given to the citizens, I am only praying for making use of that particular provision.
Okay.
Even in the new conveyance cannot be taken by any act.
Yeah.
Only some modalities may or may not be changed, but I am not here to comment on that. I am only saying presently you have a process of getting deemed conveyance. We have to quickly invoke concerned provisions and get the conveyance.
This statement is giving an impression to us that under the new act it is a being
No, it has core.
That's
No,
what I
in
want
that
clarification.
No, in that case I will clarify.
Yes.
No lawmaker will eliminate something which is in the interest of public. Okay, that protection will be there definitely, because that is part of your agreement. That is part of your agreement. Yes, sir.
Can we compare deemed conveyance and conveyance through consumer court? What are the advantages? Whether we can go through both the process simultaneously, and what is the cost involved in either of these, and FSI affected in each of these things like.
Yes, good question. See, as far as both the things simultaneously is concerned, it is not permissible, because you have to clearly give a declaration that you have not availed any alternate remedy. Even if you go to consumer court, you cannot say that something is pending before DDR and I am also coming here. Yes, for the purpose of getting conveyance, I am saying, if a builder has not given conveyance to you on time, then it becomes a service deficiency also. For that particular damage, claiming damages, you can definitely go to consumer court. For getting conveyance, also you can go to consumer court, but you have to forego this particular provision of deemed conveyance. If you are going to the deemed conveyance, you will definitely get a conveyance. And also if you are going to the consumer court, you can claim damages along with along with conveyance. But only difference in the process is, if you go to the consumer court, the builder will keep on taking the dates, he will remain absent, he will pray for restoration of the order before the same, or he will go for an appeal and all that, which he cannot do in case of deemed conveyance, because there is a proper procedure laid down by way of a notification wherein 6 months is the time frame allocated for closing the matter. Okay, and there are quick steps taken by the registrars. So that kind of delays will not be there in case of deemed conveyance. And as far as costing is concerned, 2000 rupees is the filing fees for filing the deemed conveyance application. In case of consumer court, as per the chart, 4,000 is with your state commission and 2,000 is with district forum.
So one more point is that supposing in the case of the society, the builder has not got the occupation certificate. Do the competent authority entertain such kind of applications without occupation certificate?
Yes. Without occupation certificate, deemed conveyance applications are entertained.
Entertained,
Yes.
but I am told they are rejecting it ultimately. If the occupation certificate is not there,
Okay.
they are rejecting it.
No,
That
I
is
think
what I came
no.
to
We
know.
have received many orders because it is your entitlement.
There seems to be a
occupation-
confusion on this point.
No, I am very clear. Without occupation certificate, also conveyance has been granted. We have received many orders.
Okay.
And in case somebody is rejecting that with some other observations, you can always file writ petition. Yes, that's the only thing. But in any case, within 6 months, 8 months, you will come to know about all these things. Traditionally, that was not the scene.
But sir, they are rejecting in the ADJ also.
Sorry?
In ADJ, when we are submitting the file,
Okay.
they are telling that without OC we can't proceed further.
No, let them make a written order.
Okay.
Let them make a written order because see, in adjudication, what happens is they are concerned with only assessment of stamp duty. They are only concerned with the assessment of stamp duty. They are not here to challenge the order or comment on the order of the competent authority. They don't have that authority under the law. And if you see, there is a circular of 12th April 2012, wherein how to assess this particular deemed conveyance related matters. It is very clearly given by IGR. So you have to bring to their notice this particular circular. And if at all they are passing any written order, you can definitely go and appeal for appeal before the concerned authority, just above them. For that, you need not go to High Court.
So there is a fear. See, in many cases, the builders have not stamped their original agreement with proper stamp duty, and they have not registered them.
Okay.
Then in that case, what is the liability of the societies which have applied for deemed conveyance for the liability of the stamp duty, whether it can be passed on to the society if the builder has not paid the stamp duty on his development agreement or agreement for sale, whatever it may be, under which he got the authority to construct and sell? What is the present position?
See, present position under deemed conveyance is, it is a prerequisite that every flat owner has to pay his respective
That
stamp
we
duty
are
and
paying.
registration.
Flat owners have paid.
Absolutely. If something is pending on the land, okay, it is part of the adjudication process. But at the time of submitting your application for deemed conveyance, you have to file a declaration. Because if you see the provisions of law, it is very clear. Before filing, you have to ensure that everything has to be paid. And with your undertaking, they will definitely entertain the application. But in the adjudication process, you will come to know how much amount you are supposed to
Now
pay
the
on.
point which many of the clients are asking is whether the society will be liable to pay the stamp duty in the adjudication proceedings.
Answer is
Otherwise-
yes, because if there is any deficit, if something has to be payable, then only subject to receipt of that revenue by the government, then only the title will be transferred in the favor of the
Is
society.
it not injustice to the flat purchaser?
No, then see, there is a contributory negligence of the concerned flat owner as well as the society. It is not a matter which has come up today. For 30 years, we have not taken due actions on that. Today, I get so many cases wherein builders are not at all active.
Responding.
No, they are not active. They constructed 1 or 2 buildings 20, 30 years back, and today they are not even traceable. The law protects the person who is vigilant. Like, you cannot say that after 30 years, builder has done this to me.
So this
Though
is-
it is, yeah.
This is going to be a very big financial liability for the
Financial
societies.
liability, yes, but in alternatively, you have to think on the positive side. At least with this financial liability, there are 100% hopes of getting conveyance,
Supposing
getting
the,
ownership.
Supposing the society pays the stamp duty
You are
of
owner.
the liabilities, are whether they can proceed against the builder independently for recovery?
See, as far as the land is concerned, generally in the process of this particular, as laid down in 12th April circular, they are talking about assessment of stamp duty payable by each and every member.
That's
If
okay.
every member is paying, then they are not claiming anything else on the land, provided if there is balance FSI. If there is a balance FSI, then they will take to that extent. Not on the...
That is okay, sir. That
Yes.
is
No, only that.
understandable.
No, that is very clearly laid down in the circular.
I am specifically asking on the question, if the builder on his agreement for sale with the owner did not pay the full stamp
No,
duty or did not register.
that is not again levied on you.
That's
That is not again
That is
levied.
what I'm
That is not again levied due. Supposing if you are having 100 members,
Yes.
if everybody has paid or some members have not paid, we are ready to pay by way of adjudication calculations.
Right.
Then you can regularize it.
Right.
As far as the land is concerned, they are not again claiming.
That's what I want.
They are not again claiming.
Because the people
But
are
if
worried about this.
absolutely, if there is any balance FSI, you have to pay stamp duty on that
On that.
collectively as a team.
Thank
as a
you very
society.
much.
Sir, just give me half minute. I'll just address. Continuing with your response, I had one matter. Like, and it is good for everybody to understand this. In one of my case, which I was handling before the collector, what happened is this particular one of my society's member had no copy of the agreement. He had only share certificate, or he had only some proofs to submit. Then in the adjudication process, there was a claim of about 3,80,000 rupees for 2 flats. 2 such instances were there. Then I told my clients, as per this 12th April circular, you will get the benefit. You will get the benefit. But my clients told me, don't worry, you go and pay. Because the builder is reimbursing this, the person who is going to redevelop this building. See, willfully, we only violate the law. We only entertain such practices. Then I told him, just wait for 2 months. I will try to reduce this liability. Then I went to higher ups. I went to even undersecretary in Mantralaya. They guided me. They said this particular entitlement is supposed to be given to your client. This benefit is supposed to be given to your clients. But in spite of that, my clients told me, you pay this amount. The point is, anyway, they were rich and probably they could afford it. The point is, if you are not having your copy of the agreement, if you are not having any proof of contractual relationship with the builder, there are ways and means of getting this particular exemptions. Okay, you have to make proper representation to the collector, and if he is not passing a suitable order, you can go for an appeal. And if at all that is not getting addressed, then we can definitely file an appeal before the IGR Pune, wherein their own circular has to give you benefit. By way of that particular implementation of that circular of 12th of April, you will get the discounted benefits. So the point is, in my scenario, they charged me current market rate stamp duty. But in the interest of public, I have again taken up that matter with the IGR. The correspondence, I am just still doing it. So deemed conveyance is the excellent process. It is drafted for the people, for the benefit of people, just to ensure that this entire piece of land comes smoothly at lowest possible cost from the builder and the landowners to the society. Because if you see probably about 10-15 latest writ petitions disposed of Honorable Bombay High Court, you can observe the conduct of the builder as well as the landowners. After 30-35 years from the date of construction of the building, handover of the possession, taking full amounts from the flat owners, their legal heirs are coming forward and saying that this agreement was not properly stamped, this agreement was not properly, registered. Hence, we are still owner of the property. Okay, so if you imagine a typical civil court scenario, this matter would have been again dragged for another 10 years. So in case of deemed conveyance, since there is no appeal, only writ petition is there, the disposal and getting the title is very faster. So as far as stamp duty is concerned, you are having all lawful powers to ask questions. Okay, don't just rely on the basis of because some collector has given you some order, don't pay that amount. Compare that particular amount or logic of calculation of the stamp duty with the circular of 12th April 2012. Okay, if it is in order, it is fine. Otherwise, you can just go in for appeal and get the amounts revised. Otherwise, you will get an interim order. You can challenge the interim order. You can raise issues before the same authority, before the final order is issued. You can bring it to the notice of the concerned authority, that is the collector. And if you are having some proofs, for example, if you don't have an agreement, if you have some proofs that amount paid by way of check and the debit entry is there in your passbook, or you probably bring the certified copy from the bank, produce that, you will get the benefit of stamp duty. And you are going to save substantial amount in that. Yes, please.
Sir, whether this 12th April 2012 circular which you are saying, will apply to cases where the builder is willing to execute the sale deed and they go independent.
No,
It doesn't apply.
no.
So that is a
Because it is a circular which is only for applicable for deemed conveyance.
not for the.
No, if the builder is willingly is executing something, then deemed conveyance is not applicable. Deemed
Oh.
is he is not doing purposely. That is why through this mechanism you are getting.
Is it not a discrimination?
No,
When
no.
they are giving a certain
No,
concessions.
no, it is
to
not
the-
a discrimination. It is a default. For regularizing the default, this particular amendment has come. You have to ask him why default. There is no discrimination. He is already sitting with the profits. He has already factored when he sold the flat to you. He has already factored the market amount payable by way of stamp duty and registration at that time.
Thank
So
you.
he has already taken that benefit. So he has to just reimburse it. And if he is not doing on time, he has to do with penal interest.